the new boundaries of law in the digital era. Today I will be addressing individuals with international interests such as managers or workers, including freelancers who have connections on a global scale. I will be highlighting the 5 specific aspects that these workers need to give special attention to and be mindful of. To clarify, when discussing workers with international interests, I can provide an example of a worker who may have been employed by an American company, worked for a specific duration in various locations in Europe, and subsequently been assigned to Italy. This could be, for example, the typical case, or an Italian worker who in turn is naturally moved abroad, so it depends on the nationality of the worker, it depends on the nationality of the companies. When there are global matters at hand, these are the 5 aspects that necessitate your specific attention and focus. The first thing, the contracts. So, for a worker who is temporarily assigned to Italy, the correct contract is the detachment contract. It's not that simple, because a detachment contract means that you can find yourself facing 3 contracts, which are the contract of the country of origin, the detachment contract, which regulates the detachment, therefore the temporary assignment in Italy, and the Italian contract. Why is it important to read these contracts? Because naturally there are many rules there that are not necessarily the correct ones to apply, but there are certainly some indications there. There may also be 2 other hypotheses. The first hypothesis is that the worker simply keeps the contract of their home country. So for example, I am an American worker. I come to work in Italy, but I retain the American contract throughout my employment in the foreign country. Another hypothesis. Then there's a third hypothesis. Naturally, I'm a worker. I give the example of American. It could be English, French, German. It doesn't matter. American worker coming to work in Italy, my company wants to permanently assign me to Italy, and therefore at this point it proposes me to sign an Italian contract, maybe with a subsidiary or with another company. The crucial thing to comprehend is this. Frequently, employees make errors because they believe that if the employer is a small company, there is a possibility of making mistakes. If it is a large company, it seldom makes mistakes. It is not like that at all. I have personally witnessed the largest companies make mistakes in international contracts when trying to regulate their employees. Maybe also for a bureaucratic issue, maybe because they don't have the right person in that position, but it is common to find even large companies that completely fail to make detachment contracts, or in any case, contracts that regulate these employment relationships. We arrive at the second point. The second point is what you have to do as a lawyer and as a worker, of course, is to try to identify what is the applicable legislation and the competent court that has jurisdiction over the matter at hand in order to proceed with the legal process. This is because we are all aware that Italy has a strong commitment to protecting workers and prioritizes their well-being. So this means that if I, an Italian lawyer, can argue that this matter is still subject to Italian law, attention maybe not entirely, because there may be instances where both legislations are applicable, but if I, an Italian lawyer, can believe that Italian legislation is applicable to that case, then I have a case in Italy, and probably, indeed certainly, I will be able to ask for a much higher amount of money for a potential resolution of the contract, and therefore this is another extremely important aspect that needs to be taken into consideration. And we arrive at the third aspect, which is in some way connected, the quantification of the amounts that can be requested. This is clear that the first, second, third question that is asked of me, the first, second, third question is, but lawyer, so how much can I ask? On this I want to make a separate video because it is not possible to talk about it right away. It is a very complex issue. So in general terms, we say that quantification depends on many variables. Variables are the reasons, for example, why the employment relationship is terminated. Does the worker decide? Does the company decide? If the company decided it was right to terminate the employment, and if it was not right to terminate the employment, how serious is the violation? Because depending on how serious the violation is, naturally you can ask for more or less money. Was that worker a manager or an employee? Why everything changes? Everything changes absolutely. How much did that worker earn? So based on, let's say, putting together all this data, you are able to make an economic request to the company. Often I face colleagues. It happened to me recently. I was on the company side defending a company In the resolution of an executive, I see this request arrive, which was already a judicial act. I read it and say he asked for too little. He objectively asked for an insufficient amount, that is, they could have asked for a significantly greater amount. So we must exercise caution. We must exercise caution in quantification, and that is why I state that I will allocate a separate video to this topic. The fourth question I am asked is well hooked, but what is the duration of time it takes to reach an agreement? This is a very Anglo-Saxon question. The Anglo-Saxons, unlike us Italians, always tend to say, okay, how long does it take to get this thing here? And it's a perfect question. However, in my opinion, it typically takes anywhere from 15 days to 6 months to reach an agreement prior to proceeding to court. In order to swiftly locate it, it requires a slightly longer duration of time. On what does the length of the agreement depend and rely upon? It can depend on many variables, from the hurry that the company has, from the hurry that the worker has, from any clauses that need to be sorted out, which can be confidentiality agreements, non-competition agreements, any positions that the worker has within the company. Because if I am a manager naturally at a high level, maybe I also have corporate positions, and therefore those need to be sorted out. Possibly administrative issues, civil administrative proceedings, can also be criminal proceedings that are naturally open and must be resolved. So I repeat the term, the duration naturally depends on all these variables, but let's say that if there are no complications, an agreement can easily be reached in 15 days. Otherwise, it can of course be extended. Therefore, it also relies on the fact that the more inquiries you make, and the more naturally the duration of the process tends to increase due to the increasing complexity of the negotiation. The fifth thing I am asked is, okay, lawyer, but ultimately, how can I determine if you are the right person for the job, or how can I go about finding the appropriate lawyer to handle this particular case? In this matter, I can inform you that it is crucial to engage a lawyer who specializes in labor law. It is not appropriate to hire a generalist or a special lawyer. The complexity and significance of these cases require the expertise of a lawyer who primarily focuses on labor law and has experience dealing with large and intricate matters rather than mere questions. However, it's not just about that. If you're a manager, you need to find an agent or a lawyer who specializes in or also handles manager-related matters, as not all professionals deal with managers, for instance. When you find a lawyer who does labor law, a lawyer who does executives, a lawyer who does agents, at that point it is insufficient because he must handle international law issues. But not that he would like to make inter-law issues, that he makes inter-law issues, therefore that he has experience, that he has followed many cases in the field of inter-law. So we need to inquire, do you specialize in international law, and perhaps also request for some references, that is, clarify to me which cases you have handled in the field of international law previously, and thus I am of the opinion that you can have a good understanding if that is the suitable lawyer for you or not. So these are the 5 main things that I believe are important to naturally define the best process to achieve what actually respects and adheres to the desired outcome in order to ensure optimal results and meet the established objectives in a way that is both effective and efficient. If you have any additional ideas, or if you would like to delve into specific topics of the theme I have discussed, feel free to write to me and I will be more than happy to address them in future videos. Thank you for taking the time to listen to me.